We'll go ahead and call the second case, which we'll have argument on, which will be Wallace versus Wallace. Council can come and get situated and let me know, head nods and the appropriate gestures when you're ready. We'll proceed forthwith. Okay, looks like we're just about ready. We'll call the case of Wallace versus Wallace. Let's go ahead and start with having counsel enter your appearances.
Mark Barnes on behalf of appellant Joanna Smith.
Welcome, Mr. Barnes.
Good morning, Your Honors. May it please the Court, Allison Satterley on behalf of appellee Douglas Wallace, who is present.
Welcome, Ms. Satterley. I don't know if you're both veterans of the court or not, but just to make sure the ground rules are set, we allot 15 minutes per side per argument. There's a clock on the podium that works backwards. Mr. Barnes, it looks like you reserved 5 minutes for rebuttal. Is that right?
That's correct, Your Honor.
Okay. As per our custom on the court, if we're asking you questions when the clock gets to 0, feel free to answer the questions. You don't need to ask permission to keep going as long as you're responsive to questions. Feel free to go as long as we keep you there. Are there any questions before we begin from either attorney?
No, Your Honor.
Your Honor, may it be appropriate for me to have my computer up at the podium?
Absolutely, yeah.
Okay, thank you.
One thing to note, though, we are recording the proceedings for purposes of further review and so forth. In the trial court, sometimes attorneys can wander away from the podium and so forth. Appreciate it if you stay at the podium, but as long as you're at the podium, you can have whatever you need there.
Thank you, Your Honor.
Okay. Okay, with that, we'll hear from Mr. Barnes.
Thank you, Your Honor. We have 5 issues before the court on this appeal. The first issue has to do with free speech, and that really has 2 subcategories, prior restraint and waiver. There is a second issue having to do with the calculation of child support. I will just submit that on the brief.
Let me just start you with the free speech issue. Tell me the first time that you argued to the district court that your client's First Amendment rights were being violated. Like, when did that first come up?
Well, I think it's come up prior, in the case at different times. But my understanding, I wasn't the trial counsel at trial.
My takeaway from the briefing, let me just ask the question more directly then, and correct me if I've got it wrong. My takeaway from your response in the reply brief was that the first time that you raised the constitutional arguments was in your motion to alter or amend the ruling on the modification petition.
I think that's the first time we fully briefed.
Okay, so how does that satisfy the preservation rule?
Well, it did put the entire issue before the court. I think there were approximately 5 or 6 pages in the motion.
Right, but if the motion is to alter or amend the ruling on the modification petition, the question in front of the court in the modification petition is whether the modification petition should have been granted. Do you get to raise an entirely new legal argument in a motion to amend or alter a judgment?
Well, I think you do when the court raises an entirely new argument.
Did the court in the modification ruling issue a detailed ruling on the First Amendment implications?
Yes, in the decree, disparagement language in the decree was much more limited than the disparagement language in the modified decree. So in the decree, social media wasn't mentioned. It talks about, texts and.
So you make sure I've got it right. You'd be saying that the previous language did not violate the First Amendment, but the new language that the court added did.
Well, the first version was much more subdued than the very broad language of the modified decree.
Right, but you didn't make a constitutional argument about the original language. So to the extent that you need to get through preservation, you'd have to be saying that the constitutional violation would be the new language, right?
Yes.
Okay.
It's paragraph 10A, the first sentence or two in that paragraph. So the first,
To the extent that we're analyzing it as a preserved constitutional claim, why would it not be a proper governmental interest to protect children from having one of their parents be disparaged in social media?
I think there's a proper governmental interest in protecting children. I don't think that, so we're talking about speech, and not just speech. We're talking particularly, in this case, about primarily political speech. Because,
About the children's father in the context of a divorce case.
yes, Joanna Smith is an activist for women's rights. She moved from Georgia in 2016, and since that time has been active in Utah among activist circles advocating for women's rights. She started an organization called Utah Women Unite, which in 2017 led the largest protest to the Utah Capitol that ever happened in the history of the state. She's been active in lots of different ways. And among those women's rights that she's particularly concerned about are women's rights in marriage and divorce, and women and how they're treated, in the court system and the different possibilities for unequal treatment in that
But again,
system.
all of that's true with respect to the language from the original decree. All that's true at that time, and yet she agrees to the language from the original decree.
Yes, but it says nothing about social media. So now
It does say all communications with third parties, right?
And the question
I mean-
is, so the standard that the court has to consider with the waiver is, it has to be, if you're gonna waive it, it has to be voluntary, knowing, and intelligent, and established by clear and compelling evidence. So here you have a situation of a divorce decree finalized January of 2017, and among the things in the stipulated decree is some non-disparagement language. It doesn't specifically say anything about social media. It doesn't jump off the page and hit you in the face that, if you sign this, you're giving up all your rights to advocate for women in this area.
Well, no, you're not giving up all your rights to advocate for women. You're only giving up your right in the course of doing that to disparage your ex-husband.
Well, that's not even true. If you look at the modified language, each party is restrained from posting about the other party on any social media platform of any kind. So imagine.
So she wants to publish favorable posts about her husband on her social media, and that's the constitutional restriction. I mean, it seems pretty clear that she wants to disparage him, right?
She wants to tell
She doesn't
her-
want. She doesn't want to say happy, joyful things about her ex-husband.
She wants to tell her story. And to tell your story about your divorce, your experience, to do that, it involves saying something, and even if you don't use his name, because it doesn't say you have to use his name in this language, you say, I went through a divorce, and here's what happened in my divorce case. By the broad language here, that language would prohibit that. So the problem is that the language is so broad that it really does restrict her rights. It's political speech, it's strict scrutiny, the state has to show a compelling interest. There is a compelling interest in protecting children. But how far, now you gotta narrowly tailor that, what you're doing to solve that problem.
Why wouldn't it be narrowly tailored to say to her, you can talk about women's issues and women's advocacy issues, you just don't get to talk about your ex-husband? Why
Because it
isn't that sufficiently tailored?
It takes away her story, her life story. And obviously, anybody that's gonna make a compelling argument and advocate for something like that needs to be able to tell their life story. And here, this very broad language prevents that. So.
Can I take you to one of the other issues unless,
Your Honor, can I mention one thing before we?
it's
get
your
off?
time, sure.
Okay. So I would like the court to consider a case out of the Indiana Court of Appeals called Israel v. Israel. The citation is 189 Northeast 3rd 170 at pages 179 to 180. So this is a very, very similar case. Very broad language in the disparagement clause, and the court had to weigh these same issues. The husband in that case was the appellant. Said,
Was it a preserved constitutional claim in that case?
What's that?
Was it a preserved constitutional claim in that case?
Yes.
And this isn't cited in your briefing, so
No,
is this a new case that's
This
come
is a
out
new-
since briefs were
This is a new
filed?
case that I'd like the court to consider.
It's new, so it was issued after you filed your brief? Or you just discovered it
I didn't
afterwards?
discover it until after I
Okay.
filed my brief.
What's the date of the decision?
I don't have that in my notes here. Sorry, but basically what the court found was that there was a compelling state interest in protecting the children. Now, how to tailor that narrowly, the court ultimately found, in front of the children, you can't say anything disparaging. But when it comes to talking to third parties, social media, all that sort of thing, it was too
But again,
strict.
not to keep banging the drum, but I'm gonna keep banging the drum. The preservation rules exist for a reason. And if everything you're telling us about her life story and about her political work would have existed at the time of the original divorce, and yet she agrees to a non-disparagement clause. And so it seems like the time to have litigated whether there should be a non-disparagement clause would have been in 2017 when the divorce was being litigated. I'm just not sure how we would get to a place in 2022, 2023, when this case has come before us on a modification petition, where we would say, oh, now for the first time, we're gonna consider the constitutional implications of a thing that was put in print 6 years ago.
Because it wasn't put in print 6 years ago. The language in the original decree is very, very different and not nearly as broad.
But it says she can't disparage him to third parties, what, right?
Well,
Wouldn't a social
I
media
think
post
she- I think
disparaging
her-
him be
I
a
think her
disparagement?
understanding-
Hold on, wouldn't a social media post to a third party be covered by language about social media?
well, it didn't specifically mention social media. And I think,
The whole point of social media is for third parties to read the message.
I understand that. But if you look at the standard for waiver, when she obviously saw that language, when she signed it, reading through what was put before her by her attorney, it's not, the standard is voluntary, knowing, intelligent. And there's a high bar.
Are you saying she didn't read it when it was put before her by her attorney?
No, I'm saying she didn't understand how, that would cover social media, activism, all of those things from that original language.
You're at zeros on your clock. I don't have any questions that are pressing. Okay.
Okay,
You'll have your rebuttal time. We kept you over.
all right. So you go to the next,
Well, no, your time is up. So if you want to eat into your rebuttal time, right now you could, but it would come out of your rebuttal time.
okay, well, I will reserve things for rebuttal.
Okay. Just making sure we're clear, though. Issues that are not addressed in either your argument or the responsive argument won't be appropriate for rebuttal, though. So that's the choice you have to make. Okay. Ms. Satterley.
Good morning, Your Honors. I'm going to do my best Julie Nelson impression. This is my first time before you all. I will be happy to talk about the First Amendment issue. You can interrupt me if you want or direct me elsewhere, but we did believe that the district court was correct.
Can I start you with an initial question? You didn't give us a background section or statement of the case in the brief, and in the reply brief, they've asked to strike your brief. You haven't had a chance to respond to that? Here's your chance. Fire away.
Thank you, Your Honor. We did not believe one was strictly necessary in this matter. I did read the reply brief that this was somehow more burdensome for them to respond to our brief because there wasn't a background. I don't see that that is a very valid argument. It's clear what our argument is. It's clear how we address each of the issues they raised. I don't think in having a specific set-apart background argument that made their work harder, that they would be entitled to fees as a reason for that. I apologize if it made our position harder for the court to understand. I do think that what we did write was pretty clear, though, and I do think we were able to distinguish quite a few of the facts that were put forth by the appellant and to give a bit of a different background in the body of the argument.
Okay.
Does that answer your question?
Yeah. Yes.
Thank you. So going back, I do believe that the district court got this correct. The first time this issue was raised was in a post-judgment motion. I do want to also address for the court that in 2019, the second district court did address social media posts. Ms. Smith had made some posts and was ordered to take them down in order to show cause action. So this was not the first time this had been addressed in that sense. Ms. Smith knew about this.
In this case, when it was pending in the second district.
Correct. So the court did address the issue of social media posts way back in 2019. And even then, Smith did not amend her petition, her counter petition. There was nothing until after a 4-day trial was complete, and we had an initial modified order. It was only then she wanted a new bite at the apple, so to speak, and raised this issue.
So his argument in response on the preservation component of this is the first time that social media gets put into the ether by a court is in this modification ruling.
Correct.
Which is why he thinks that he gets to preserve it through the motion to amend or alter that judgment. And your response to that is what? Just make sure I've got that pinned down.
I mean, they did raise it in a post-judgment motion, and the court, because it was a constitutional issue, did address it. I mean,
I underheard you, correct me if I'm wrong, but I understood you just to say that the issue of social media posts violating the original non-disparagement clause came up in 2019 prior to the modified decree. Is that correct?
That is correct.
Okay.
And at no time between, quite frankly, the issuance of the decree and post-trial was the constitutional issue ever raised. It was only in that post-trial motion. And again, the district court took it upon themselves because it was a constitutional issue to flesh out that issue. Because I think the district court knew, having been involved in this case as they were, it was going to come back. And here we are today. And so we have more findings than I've ever received in any family law case on multiple issues. And I do think the district court was really clear in why they ordered what they ordered when it came to the speech issue.
And you think, in essence, this was a clarification
Yes.
of what was always the court's order.
Yes.
Let me make it clear, social media is an aspect of communication with third parties.
That's our understanding. Yes. I think that was clear at the time. And I think Your Honor put it perfectly. When you post on social media is where third parties live. That is all of what social media is. And I think social media is also particularly unique in that if I have a conversation with someone, say in a room, and that's not being recorded, that's it. That's the end of the conversation. It stops right there. That bell stops ringing. If you post something on social media, that keeps talking, right? That has outward effects. It can be there for months, it can be there for years, it can be discovered. And in this case, the concern was that kids are gonna find this, these specific kids of the parties. The court made ample findings that these kids acutely knew how much their parents hated each other, right? That's replete in these findings. And so
It's
the
a
court—
very robust ruling on that point.
very robust, uncomfortably robust. And I think, the court was right in two senses. First, she waived her rights, and it was a broad waiver, that's true. But she did it. People waive rights all the time. People sign non-competes. People People do that all the time, especially in family law cases. There is nothing that says she can't. There's nothing in the US Constitution, there's nothing in the Utah State Constitution that says you can't waive your rights. Even if that weren't the case, there is a very compelling state interest in protecting these kids from their parents' animosity and their disparaging of each other and the possible affection of, or loss of affection for one or the other. Again, I think the trial court did an amazing job at specifically denoting just how much of that there was in this case and why this provision was so important.
Can I take you to a different issue?
Absolutely.
Okay. I want to take you, it's later in the briefing, but the special master
Yes.
issue.
Yes.
Explain to me how it could be in the best interest of children to change custody based on one of the parents not paying a special master fee.
So
Which
I think,
seems to be what Judge Scott says might be possible in this case.
yes, and I want to be clear that what Judge Scott said was specifically legal custody, not physical custody. We're not talking about physical custody of the children, because I do think that would be problematic. We don't want physical custody of the children to ping pong back and forth. That's very clear. What Judge Scott was concerned about was legal custody. And again, it comes back to the difficulties these parties had in decision-making, in communication. That's why we had a special master in the first place.
Okay, but even legal custody carries implications for the children's lives.
Correct.
And so which parent does or does not have legal custody is going to impact the children's lives. And we're kind of back to my question. I take the point
Sorry.
that is a point of distinction. But even still, on that narrower ground, why, you'd still have to have a finding that it's in the best interest of the children to change legal custody. So how could a court say that it would be in the best interest of children to have one parent versus the other have legal custody based on one parent paying or not paying special master fees? I'm trying to work through that in my head, how that can get you to a best interest determination.
So part of the history in this case, and part of the findings that the district court made, were that there was a history of not paying professionals in this case. Special masters didn't get paid. Ms. Smith tried to discharge the PJL's fees in bankruptcy, and these are all folks who were there to help this family unit. There was a lot of evidence that,
But if you've got a history of not paying, you can handle that through garnishment orders or the like. You can hold a party in contempt. Why does that? How does that get you to the end point of changing custody?
so I think that the focus really isn't on just the non-payment and the contempt of that. It's how does not having these people affect these kids? So the special master was given a lot of discretion to make interim decisions, pickups and drop-offs, what kind of medical care kids may need. Do they need, to really be the functioning person in this co-parenting relationship. If that person's not getting paid and they get taken out, these kids are in the lurch. I think that was the concern that the trial court had was, let's say people move, kids have to go to a new school, special master bounces because no one's paid them, parents can't agree on where this kid goes to school. And let's say they fight up until the point school is starting. That's gonna hurt these kids. Same thing with medical care. If they need important or discretionary medical care, and they can't agree on it, and the special master was specifically tasked with making this decision for these kids, if they're not there to do it, I think the trial court had enough evidence to be concerned that it simply wouldn't happen.
One of the things that strikes me as I've thought through that particular issue is I wonder whether there's anything for us even to review on that. Because it'd be one thing if Judge Scott in the future changes legal custody based on a non-payment.
I think the issue's a bit moot. It hasn't happened.
I mean, it's not even necessarily moot.
Maybe not right.
It's not right.
Excuse
yeah.
me,
Yeah.
that's the correct term.
It's totally fine. It's a ripeness problem because
Right.
it just seems like we'd be issuing something of an advisory opinion unless and until Judge Scott actually acts on that.
I think that's a really good point. It
'Cause
hasn't
she
happened
did-
yet.
As you pointed out in briefing, she didn't say she would change
No.
custody upon non-payment. She
No.
said she would consider it.
It was discretionary.
And at bottom, she's probably wanting to put the fear of God in these parties. It's critical to the smooth functioning of this arrangement that the special master handle these details, and the special master needs to be compensated. FYI, the special master doesn't get paid. I may change custody, but it's just a may.
Right.
I'll consider it, and it may or may not happen, and I think you concede. If that was actually the one and only basis for a change of custody, we could well have a problem.
Yeah.
Especially if there were financial hardship or some other issue. But
I think
I
it would
think
be,
the point was well made. It's not right for our consideration whether or not we choose to editorialize about even the may part of it, I guess is a different question for
Yeah.
the opinion drafting, but
and I do think there was no, with respect to the non-payment issue, I'm sure that the district court, and nothing in the opinion, or excuse me, nothing in the order says they wouldn't do this, but, why did someone not pay? I think there's a huge difference in someone who is working, who's paying their other bills, going on discretionary vacations, then suddenly choosing not to pay the special master versus someone who's really having to cut down on expenses, is in a really hard spot. There's no reason that could not be treated differently. But I'll stop talking about this because I agree, I don't think it's right. So with respect to the other issues, I think in short, we believe the district court got it right. It was up to their discretion, they did not abuse that discretion, and I really don't have any more to say on that unless your honors have any questions for me.
I don't have any questions.
I don't.
Right, thank you all.
Thank you. Appreciate your argument. Rebuttal.
Thank you, Your Honor. Yeah, the special master issue, changing legal custody, I understand the court's concern, but let me give the court a little bit of background here. When you make a rule that says based on payment, and you have one party, the appellee, who of the joint income makes 87% of the income, and the other party, who at the time of the trial was actually unemployed and had just lost a business, but was imputed 13% of the income. There's a giant discrepancy in power in that situation. So the threat's really towards Smith in this case as the one who's, probably doesn't have, is the much lesser economically able of the parties. So
Well, but when we're looking at the special master issue, we're much further down the analytical chain. I mean, what you're talking about are issues about alimony and child support and the division of the marital estate, but the law sort of creates a construct under which the estate's divided equally and so forth. So presumably she has access to some assets, but on this special master issue, why would that be the question before us? I mean, what we have is Judge Scott saying to both parties equally, if you don't pay.
yeah, Judge
I
Scott
know.
only cited the special master with that kind of penalty.
But she didn't direct that toward one party or the other. She said that to both parties, right?
Yes, she directed it to both parties.
Okay.
I'm saying if you look in the context, though, one party vastly superior economic ability than the other party, there is some real, discrepancy there. And there was no history, and is no history, of Smith not paying a special master. Special masters have always been paid. There is no.
So why do we need to
History.
rule on this now? I mean, you've heard the discussion about ripeness. Tell me why we need to rule on this now.
Well, I think in a case like this, where the concern is for, and I think the court did a great job of pointing it out, the kids' lives can be impacted significantly for a change in custody, whether it's physical or legal. And that can have a drastic impact on the children's lives.
But it's all hypothetical at this point. She hasn't changed custody based on this. So what is there for us to rule on?
Well, it's taken 2.5 years since trial for us to get here today. Children are growing up quickly. 2.5 years, 3 years.
Right, but do you see the problem that we're facing? If we were to write an opinion saying, Judge Scott, you cannot change custody in the future based on this, that's an advisory opinion.
I think the court can, though, rule that using that kind of language in an order is improper. And that is, I think, a very important
And how would
function.
we, just thinking this through and drafting the opinion, how would we assess it's improper if we have no basis for what the district court did with it, right? All we have here is a statement that the court may, and that was the term Judge Scott used, was may consider this in the future at some unknown point, along with so many other factors. I mean, this is a challenge we have as an appellate court, right? We can only review decisions that were made by the district court, and here we don't have a decision that was made because she hasn't hasn't made one, right? We don't know what factors she considered. We don't know if there was a non-payment, what the reason was for that non-payment, and how Judge Scott treated the reason for that non-payment and weighed it against other concerns. I mean, we just don't have anything to look at. So how do we craft an opinion that really evaluates this in any way?
I think that the court could just make an opinion with a statement in it that it's improper for a court to change custody based solely on non-payment of special master fees, and that the court
But
has
how is
already
that not
done.
advisory, though,
Well,
if it hasn't been done? We're not striking down a decision. We're not saying you changed custody on this basis and that was incorrect and we are reversing it. This would just be a statement into the ether that says courts can never consider non-payment of fees to a special master at any point in a divorce case in determining legal custody, right? That would just be a general pronouncement that's not moored to any actual findings or any decision.
Well, I think what has been done is to put that language in order. So that has happened, and I think the court could rule that that is improper to include in an order.
It seems like the best you could hope for is some dicta in a footnote to the effect that if this may ever became a shall, it is potentially problematic without full consideration of other issues.
Well, and that might be a way the court could handle it.
But it surely has a very advisory, dicta-like tone to it as I picture such a footnote.
Yeah, and I think it's important in a case like a divorce case. A lot of cases are different than this. But those kids are gonna be impacted. Say she did that. Say she actually made that change. And we have to go through an appeal again. And we're talking 2.5, 3 years down the road before the court ever addresses it. I mean, the youngest child right now is 12. He's gonna be 15. The other 2 children are already gonna be adults. It's just kind of a little bit too late. So maybe the court, in its function of supervising the lower courts, does have a role in at least cautioning those lower courts that this kind of thing shouldn't be done.
Okay. I see that you're at zeros, so with that, the argument will be concluded unless there are questions we wanted to ask. Looks like
Thank you, Your Honor.
All right, thank you both for your arguments. We will do our best to issue a decision as soon as we can. That concludes the second case. The third case for argument today is set for 11 o'clock, so it looks like we're going to take a short break, and the court will resume at 11 o'clock for the third case.
I've never spoken on my computer. Of course, I do it today. Sure did. Like an idiot.